everyone, it's Friday, November 8th, 2019. I have a letter here from Ray Kahn, and his prosecutor said it's the most important tax case he has ever had. And he has a wife named Cookie who loves him, and I will read it to you. It's not dated. It says, "Dear Rudy and Aaron, I read the recent letter that you sent me on October 19th, 2019. It is truly an inspiring letter. In my mind, as I boiled the message down to its essence, you are saying we know that by standing up and demanding that our public servants obey God's laws when dealing with God's children, we are putting ourselves in harm's way. But we are going to do it anyway because that is what our Heavenly Father expects us to do." Now, this is going to be a long letter, you guys, so I'm letting you know. And it's not dated, and it's typed, so I shouldn't have any problem with reading the writer's script. "I know the Lord is very proud of you for taking this stance. It's not easy. You could end up losing your earthly possessions, your liberty, or even your life for taking such a stand. I took such a stand in 1979 against the IRS. It has cost me millions of dollars in money that I could have made during the 15 years and counting that I have been imprisoned because of the stand that I took, mentally, emotionally, and physically. The toll on you and your loved ones is unbelievable. People have no idea. Most think you are crazy, right?" And my reader's notes say, well, I don't know if they think we're crazy, but I understand where he's coming from. And what else I was going to say is that, it takes its toll, and God has our back, and it's unbelievable. And this is what's written in the Bible, so this is what we expect. And I'll also add, there are things we'd rather be doing, but I don't think there's anything more important than advocating for innocent political prisoners that are targeted for exposing government corruption. There was something else, but I'll think of it later. Going on. "You should go along to get along" is a saying that more than one person said to me over the years regarding the foolish stance that I took. However, the way I looked at it, those are the same type of people that looked the other way in Sodom and Gomorrah as the homosexuals ran the city and committed their abominations openly. And when God decided that enough was enough, they died right along with the queers because they tried to sit on the fence. Question is, sitting on the fence acceptable in God's eyes? The Bible says no. Having said all that, the Bible also says that we are to be as wise as a serpent and as harmless as a dove. In other words, there are ways to protect yourselves from the slings and arrows that are already being hurled at you and the heavy artillery that is sure to come later if you don't cease and desist. I'm going to give you some armor that if I would have had it before I had gotten to the litigation stage, I would not have gone to prison. Ooh. Okay, this is me. That sounds very interesting. And I think that I heard the lawyer from Alex Jones this week say that he was also the lawyer for Wesley Snipes. I could be mistaken, but I think that's what I heard Barnes say. He's a lawyer and he has a new website and a lot of prisoners are excited about it. And I forget the name, something about, I don't know. Anyway, carry on. Unfortunately, a lot of the knowledge and documents and evidence that would have kept you out of prison, you only acquire while you are fighting the beast from the inside while you are trying to regain your freedom. After my first trial in Florida, the marshal sent me to the La Tuna FCI prison in Anthony, Texas. After about 6 months there, all of a sudden I was told to pack up that I was going to be transferred. Cookie went online and saw that I was going to Washington, D.C. for a new trial on different charges, so I talked to an attorney that was also imprisoned in La Tuna about this new development. He told me to do the following. 1. For the first time you go before a judge, you say, I am not a party to this action as the defendant, and I am not the same entity, unquote. He said that you don't answer any other questions. He said that if I did that and did not sign a fingerprint card, they would eventually have to let me go. However, he refused to elaborate. I don't know why, as to why that approach would be successful, which in turn caused me to wonder whether that would actually be a successful strategy. However, when I was taken by the marshals to D.C., I did refuse to sign a fingerprint card. The marshals did, in fact, admit that I could not be forced to sign any document. When I went before the judge for the first time, arraignment, the judge talked with every defendant and their attorney except me. He never even looked at me. Unbeknownst to me, the judge had also hired an attorney to represent me without my knowledge or consent, as he assumed I was the defendant. I told the attorney that I did not want or need him and to go away. He would not do it. The judge suddenly turned my way and told the attorney to plead for me. Immediately, I jumped up and told the judge that man was not my attorney. The judge demanded that I sit down and be quiet. I kept insisting that man was not my attorney. The judge then ordered the marshals to take me to a holding cell. I found out later by reading the transcript that the judge later forced the attorney to plead for me, even though the attorney stated on the record that he had not been authorized to plead but me to plead. I'll repeat that. Later, the attorney to plead for me, even though the attorney stated on the record that he had not been authorized to plead me to plead. Authorized by me to plead. All at the next hearing, which was held without the other defendants present, the judge addressed me as the defendant. I objected to him making that assumption. I stated that the defendant and I were not the same entity. I also told him that I had not seen any evidence in the court record that proved that the defendant and I were the same entity. I then asked the judge if he had seen any such evidence. Guess what? He refused to answer the question. He also said that he would refuse to answer any other questions like that. I then asked him to make a judicial determination that the defendant and I were the same entity. He said, all right, but never did it. He just illegally assumed personal jurisdiction and continued on. At that point, I just did not know how to force the issue to a conclusion. That was in 2008. And I, the reader, will add that would be 11 years ago. I did not find out until 2017, 2 years ago, about the key document that I should have demanded that the prosecution produce that could have ended the charade. One of the inmates here at Rivers had asked his attorney to send him a copy of the case file the attorney had regarding him. In the folder of documents that he received as a document entitled Rule 5C3 Affidavit, when I read it, I instantly understood why the attorney in La Tuna told me to say, I am not a party to this action as the defendant, and I are not the same entity. The defendant and I are not the same entity. I understood that this is the probable cause affidavit that is used by government against agents to allege that the upper and lowercase names not named natural person is the same as the all uppercase named entity. Oh boy. This was the, quote, evidence, unquote, that all agents used to get a magistrate to authorize the issuance of an arrest warrant. As you can see, the arresting agent is stating under penalty of perjury that he asked Morris, the man, if he is Morris, in capital letters, the defendant. And he said that Morris, small letters, the man, said he was. But after reading the affidavit, Morris, small letters, said he was totally unaware of what the agent was really doing, and that he would have absolutely denied any connection with Morris in capitals, the defendant, had he been informed as to what the agent was alleging. Morris's problem, since the agent was swearing to these, quote, facts under penalty of perjury, they stand as truth unless rebutted by a counter affidavit. Question: how do you counter something that you don't know exists? Okay, and let me just say that just an outsider looking in on this is my own personal opinion here on the side. This all sounds like witches and magic and trickery and a bunch of hooey that is ridiculous. And I'm not saying that Ray Kahn is guilty of this. I'm saying the courts are guilty of a lot of this. But what do I know? Continuing on. This is the, quote, probable cause, unquote, affidavit that is required to be attached to the arrest warrant pursuant to the Fourth Amendment warrant clause, which states, quote, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, unquote, emphasis added. So how did the agent confirm that Morris, the man, I don't even know who Morris is, but okay, and the defendant, Morris, were the same entity? The agent stated that Morris, the man, confessed that they were. Also, Morris signed the fingerprint card. Guess what name is on the fingerprint card? Yep, it is the all-cap name, which is why the attorney said not to sign that card, as it joins the two entities with the same set of fingerprints. That signed fingerprint card can be used in court to identify you as the all caps name entity. An unsigned fingerprint card could not be used. I'm sure this modus operandi is standard operating procedure for all agents asking a judge to authorize the issuance of an warrant for an arrest, as the affidavit makes a prima facie case. Quote, indeed, no more than affidavits is necessary to make the prima facie case, unquote. U.S. v. KIS 658 F2D 526, 7th Circuit, 1981. Okay, we're on page 4. See how many pages this is. Oh boy, I don't have to read all that. There's at least, oh boy, there's at least 9 pages here. I showed a copy of this affidavit to a number of jailhouse lawyers here. No one had ever seen an affidavit like this. We all sent off letters to the U.S. Attorney Office, the clerk of the court where the trial was held, and to the attorneys who had defended the inmates. To date, no one has been able to get that affidavit even though it is not exempt from disclosure, exclamation mark. Are you starting to smell a boatload of rotten fish? Question mark. I have since sent this affidavit to people on the outside who are legal research types, which I add, not me. None of them, none, capital N-O-N-E, of them have ever seen this affidavit, much less have a copy of one. However, without it, an arrest warrant could not be issued. Think of all the millions of arrest warrants that have been fraudulently issued because the agent falsely stated that the man that was arrested confessed that he was also the all caps named defendant, and the man did not rebut the affidavit with a counter affidavit. So, how would I use this document today? Anytime that I was confronted by any agent from any agency, local, state, or federal, about anything civil or criminal, I would demand to see a legal document that has the name capitals of the person they are looking for on it. Reason: if it is a legal document, it will always be written in all caps. I would then state I am not a party to this action as the entity and I are not the same entity. I'm reading it the way it's spelled. I are not the same entity. If they try to insist that you are that entity, ask them for the evidence that they have that proves you are the same entity. Brackets note. What they try to do is ask you to tell them your social security number and your birth date, but neither is legal evidence. Even the FBI states the only way they can positively identify someone is with their fingerprints. Bracket. They have none. Remember, you are not saying that you are not the defendant. You are saying that you and the defendant are not the same entity. It is an entirely different challenge. With this 5C3 affidavit as my ace in the hole, I would demand that they produce a similar document. There is no way they will ever do it because that would expose the fraud that they have been perpetrating on the American people for God only knows how many years. I do not believe there is any way they would continue to pursue you, as they would not want this affidavit to potentially get into the hands of the general public. Important. I would keep this document in a very safe place. I would also pass it around to others that you think would understand the true significance of the affidavit. Why? Because many people have tried to get a copy of theirs, including me, without success. I truly believe that the only way we got this one is by God's grace. If we could get more, that would be fantastic. Please put the word out that we are looking for copies of Federal Rules of Criminal Procedure Rule 5C3. Identity affidavits belong to people that are currently in or have been in past federal custody because they have been criminally indicted and arrested, as this affidavit is the quote, probable cause, unquote, that is required by the warrant clause of the Fourth Amendment of the USA Constitution. But if we can't get another one, we can all use this one as evidence, unquote, of agent wrongdoing. We can demand that it be produced as we are filing a counter affidavit rebutting the agent's lies and failure to provide full disclosure, and unless the agent can come up with real evidence that the all caps name entity and I are the same entity, the case must be declared void. ABINITIO, ab initio. and expunged from the court record, and we must be well compensated for injuries. Remember, the maxim of law, quote, if it is not in the court record, it does not exist, paraphrased. In my opinion, every patriot that is currently in prison should do a FOIA/PA request to the prosecuting U.S. Attorney's Office requesting a copy of this affidavit along with a copy of the arrest warrant itself and a copy of the criminal complaint. I would also ask for the same documents from the clerk of the court where the trial was held, and if the person was represented by an attorney, from the attorney as well. They all should have copies of those 3 documents. If none of them can produce the affidavit, that is proof that the arrest warrant is constitutionally invalid, right? So, to me, this is where the fun begins. I have seen 2 inmates here at Rivers file a lawsuit against the judge and prosecutors alleging false imprisonment instead of filing a habeas corpus, and I have seen both of them win. The latest one in July of 2019 was offered a very hefty sum of money plus expungement of the record and immediate release if he would sign a non-disclosure agreement. However, he is still here because, as he told me, he has been falsely incarcerated for almost 20 years and he wants more money than the government is offering. Candy Lyles is doing a similar lawsuit for me right now. I will keep you posted as we proceed. A question that I have been asked more than once regarding the all-cap name. People have challenged the all-cap name in court. Why did they lose? In my opinion, they lost because there was the probable cause affidavit in the court record saying that you and the all-cap name are one and the same, and you did not rebut it with a counter affidavit or sworn testimony. Plus, they did not have a copy of a Rule 5C3 affidavit to submit an evidence of the fraud. Plus, I'll repeat, they did not have a copy of a Rule 5C3 affidavit to submit evidence of the fraud. I hope this helps you. You guys have been so helpful to Cookie and I, and we are so appreciative your love and support, and most of all, your great attitude. I know God is happy with you. May God bless you greatly. And he signed his name, and he's not using all caps here. P.S. I was told the lady who appeared in the Los Angeles Superior Court got her case dismissed when she said the following. Number 1, I am not a party to this action as the defendant, and I are not the same entity. Number 2, I do not consent to be involved in these proceedings. Number 3, I do not consent to being used as surety for this case or this defendant and these proceedings. Number 4, I demand that the bond be immediately brought forward so I can see who will identify me if I am damaged. I was told the judge dismissed her case immediately. I can believe that for 2 reasons. Number 1, she is challenging the all-cap name properly. Number 2, she is asking for a copy of the bond that will compensate her for any injuries she might incur as a result of this action. What I have seen personally is that when you ask for the copy of bond for the judge, prosecutor, marshal, and clerk of the court, the clerk will not respond to your request. Myself and others have tried to get them. 28 U.S.C. says that anyone can get a certified copy of them. Specifically, it states, 28 U.S.C. Section 1737, copy of officer's bond. Any person to whose custody the bond of any officer of the United States has been committed shall, on proper request and payment of the fee allowed by any act of Congress, furnish certified copies thereof, which shall be prima facie evidence in any court of the execution, filing, and contents of the bond. We have been unable to get the clerks at several district courts to tell us who is the custodian of the bonds. Why do you think they are obviously hiding this information from us? I believe it is because that when people try to sue these officers, they all claim what? Immunity, right? They all claim what? Immunity, right? But if they were immune from suit, there would be no need for a bond, right? However, if you had a copy of the officer's bond that you are using, it is proof that he or she is not immune from suit. The two guys here that I told you about that sued the judge and prosecutors in their case won. So it is obvious that they can be sued. Maybe you can find someone on the outside that can get a copy of a judge's or prosecutor's bond using 28 U.S.C. 1737. If so, I would be happy to pay the certification fee to get a copy of it. Maybe somebody listening could do that. Get a copy of a judge's or prosecutor's bond using 28 U.S.C. 1737 because he would be happy to pay the certification fee to get a copy of it. Enclosed. 1. Copy of Rule 5C3 affidavit. Number 2. The document that is in 99% of all defendants' file. See the box that is checked waiving an identity hearing. Of course, by doing it, isn't he, quote, confessing, unquote, to being the all caps name entity? I believe he is. A maxim of law is, if you don't object, you agree. Paraphrased. Number 3, a copy of the court transcript where I am telling Judge Kennedy, the first judge, to stop referring to me as the defendant. I am also asking him if he has seen any evidence in the record that proves that the defendant and I are the same entity. Finally, I ask him to make a judicial determination that the defendant and I are the same entity. That's the end of page 9. If you don't want to listen to me reading this, you can also go to the Dropbox because I'm pretty sure Rudy will upload each and every page of this long letter to the Dropbox because I don't think I'm going to be able to read all the rest of this. But that's the end of his personal letter to us all listening tonight. Thank you for tuning in. We appreciate your prayers and support and letters to Eddie Ray Kahn. He's a wonderful Christian man, and his wife is so lovely. We love her. Her name's Cookie, and she has been to hell and back dealing with all this nonsense because in her husband's case, there is absolutely no victim whatsoever. And I love her. And the next pages are sealed, filed in 2009. And it's a bunch of court documents. I think there's one. There's a whole bunch of pages here still. Maybe I'll read them. Let me take a breath, okay? Filed in open court in Florida. Oh boy. Proceedings.
Which one with the questions? I need that list with the questions, the 4 questions.
What questions?
Like, I'm not the defendant, and...
I don't know. Take the whole thing if you want, and I'll stop here, and you can upload the rest to Dropbox. This is everything I already read right here, and that's all the rest of it. But I'm just thinking tonight that I hope everybody prays for these prisoners because there's no victim in their crimes, and they are doing decades, literally, behind bars without their loved ones, causing absolute pain and torture to themselves by coughing naked in front of other men and women prisoner guards in their prisons, and this is an absolute atrocity, and it needs to stop. And, as far as I'm concerned, President Trump needs to get some real patriots like Casey Massey in his cabinet, because he has got a bunch of swamp monsters in there, and there's absolutely no reason why Casey Massey needs to be eating God knows what while he is trying to stay out of prison, and I don't blame him at all for that. And this world is upside down, and I really have no hope until Jesus comes back. I know some people do have hope, and I know people have been saying this for 2,000 years since Jesus was on the cross, but I just want to say that I don't think there's any hope to turn this ship around. It's too far gone. I saw t-shirts today for babies and children that say absolutely abhorrent things that you can order online, for pedophiles to order online. It's just making me sick right now. And I pray to Jesus, our Lord and Savior, to come and rescue the prisoners that are behind bars that are innocent.